Back out again tonight. I'm Dave Anthony, Fox News.
Lawrence County depends on WDXE. On the air since 1951. This is the legend. 105.3, 95.3, WDXE.
It's time for Bulletproof Estate Planning, and Stan, it's been a while since I've seen you.
It has, pre-holiday.
Yeah, we took the holidays off.
We did.
And had good ones, I hope. Did you?
Yeah, it was good. Good. You had fun. Well, whole family was home, but usually not the occasion.
Yeah, yeah.
You know, my daughter lives in Florida, and she doesn't usually come around Christmas time, but
Yeah.
she did this time. And
Yeah.
had the grandkids, and yeah, we got a third one on the way.
That's awesome.
And so, yeah, it was a good time. It was a good time. It was a good 2 week stay, and yeah, we enjoyed it. So, you know, we had our show on the Friday after Christmas and the Friday after New Year's, and we decided we were going to not be here, and you weren't here, and put her a little on autopilot. I think we just played one of our pre-recorded shows.
I think so, yes.
And that's okay. The listening audience was probably a little low on those holidays. I don't blame you. You know, I wanted the time off, and so did you.
Yeah, we had a good time off, but it's time to go. Yeah, I was telling this morning, you know, it's January 9th, and January has its legs, and we're running. It's time to go.
You know, January is probably the fastest going month for some reason. You figure, okay, we got the whole year ahead of us. Next thing you know, it's spring.
That's right. That's right. That's right.
To do any stock trading, I can't remember the quote, but I remember somebody made a quote that the last thing you ever want to do is buy a certain option in January that expires in March or something. It's here before you know it. You know?
Yeah.
But anyway, yeah, well, you know, and along those lines, you know, we do our seminar every other month.
Yes.
And we specifically pegged this one to be, you know, after the holidays were over. You know, everybody's sort of getting back in the post-holiday groove, post-holiday depression, if you got any, or whatever you've got. So we have a seminar coming up on the 24th. So that's a couple weeks out.
Yeah.
And it's going to be right in Pulaski at the Star Theater. And we've already got a pretty darn good attendance for that from what the girls tell me. They keep track of that stuff, and they mentioned to me, you know, we got good attendance to that, and usually they get quite a bit right before. But, you know, the Star Theater is a pretty big venue, so we can put a lot of folks in there. And so if you have, you know, if you want to come to that, that'd be a great thing to do. That's a Saturday, the 24th of January.
Yes.
And we always do Saturdays at 10 o'clock in the morning. What we call the seminar is Wills, Trust, in the Nursing Home. And that's what we're going to talk about. So if you want to hear some more about this, just give us a call at my Pierchoski State Law, Pierchoski Outer Law. I'll give you the number now, and I give it at the end of the hour as well, 931-363-7222. Or you can go to my website, Estate Plan Stan, and you can sign up that way too. RSVP. The RSVP is a very loose process, just one head count.
Yeah.
And you know, inevitably people can't make it at the last minute, and also inevitably we get people that walk in at the last minute. So we just try to have enough chairs ready for everybody. But of course with a theater, it's not going to be that big a problem because it's a theater and there's nothing but chairs.
That's right.
So we're not a problem. So, but yeah, I'll bring that up again at the end of the hour. But you know, it might be a good way to start the new year is giving some thought to this estate planning.
Absolutely.
You know, with all the uncertainty in the world, it seems like. There's an old saying that says, may you be blessed to live in interesting times.
Yeah, we are that.
I think we're very blessed.
We are that indeed.
They are definitely interesting times. So.
Yep. And of course today we are live, at least for this hour, and then it's of course on Facebook, YouTube. We're here on WDXE AM 1370, 105.3 FM, and Facebook and YouTube. And while we are live, you can call 766-9393. That's a 615. I'm sorry, a 931 number. 931. 766-9393 if you'd like to talk to Stan this morning.
Let's call that number 615 and see who answers.
Yeah, we should. See whose phone number that is. That's right.
Yeah, I was going to go over a few things. You know, last time we were here, I went over my biblical perspectives on estate planning.
Yes,
it's fun. I like to do that every year. It's just fascinating to me how everything we do today is a concept that was brought up eons ago.
Exactly.
You know, I once said, I may have even said it that day, but you know, when you research something legally, you know, the way you learn research is through what we call precedent. Meaning, you go and you research what the courts have said. Now, you know, like you say, you're researching an issue, and they'll say, well, the court will say, here's the answer to the question, and they'll cite the case where they said that before. Maybe it was 10 years ago, but 20 years ago. And then you go to that case, and you'll cite something that they said before. Right. It's called precedent. It stands for once settled, always settled. And so they're not likely to change their mind. It happens very rarely, but they say this is where we stand, right? And you go back and you keep going back. Now, when I was I was researching an issue when I was in criminal law one time. I got into some cases were back in the mid 1800s, you know, Civil War area. So we didn't go back that far, and they constantly refer to what they did before. And so I often say on this concept of inheritance and, you know, leaving property to your subsequent generations, and the whole concept of passing, you know, being good stewards of the land and passing it on for your, you know, your use. I say if you research it far enough, you end up getting your feet wet crossing the Jordan River, because that's where it comes from.
Yeah.
You know? And so it's nothing new under the sun. You know, we do the same thing, even the same concepts. Remember we talked about leaving equally, leaving unequally, leaving it delayed, leaving it with terms and conditions and strings attached. All that's been done way back when. So that's fascinating to me that that's the case. And you know, a lot of things in life are like that.
Yeah.
You know. So anyway, we did that, and then we had we were gone for a weekend. So now we're back, and you know, it's tough in January because the next holiday or real holiday is not for a while, right?
Yeah.
And so it's going to be a while till we get some time off again.
Yeah.
So anyway, I want to talk about a couple of things. I want to talk about some things, the cases that came up over the holidays. So you know, we do a lot of trust writing, a lot of pre-planning on estate plans. We also do 10-care eligibility.
Yeah.
And so the 10-care eligibility is always exciting because it's like a free-for-all. You got a set of rules, and it doesn't seem like nobody really cares about them, but except me. It's frustrating when you feel like you're the only one playing by the rules. But that's the way to do it because we always prevail, but it is frustrating. But anyway, we had a couple of cases that had some issues, and one of them came through just the way we wanted it to. It was they came back with a denial, and we filed the appeal.
Yeah.
And it's like they didn't give us an appeal hearing, so we were concerned. And just before we reached out to say, hey, you know, you have so many days to give us the date, and we're coming right up on it or went past it, and we get a letter that says we've closed your appeal. I mean, here's the way 10-care write letters. I mean, don't ask me why they do this. Somebody sat down and thought that this was a good idea, and I can't. But you open up the very first sentence and say, we are closing your appeal. Okay, to which I kind of say something like, the hell you are. I mean, this is a legal issue. You can't do much of anything without my permission. You know, it's like I have an opportunity to be, you know, say, okay, yeah, we want this dismissed. Well, you know, I have an opportunity to be heard about that, you know, before a magistrate or a judge. You can't just unilaterally cancel somebody else's appeal. If that was the case, if you could do that, why offer the appeal process at all?
Do you think they do that to bluff?
Well, but
they think maybe somebody doesn't know better and they'll just go away?
Well, they say we're closing your appeal, and that your file will be closed. You know, something will the appeal file will be closed. But then on page 3, it's like a 9-page letter to get. Page 3, it says we have revisited your case and decided that you are eligible. So I mean, it seems like they should start with that to me, because it kind of gets me a little fired up. I mean, I'm used to reading them now, so I know where to go to get the answer. But
that's amazing.
We're not the only state that does that. Because, like, you know, when you get an approval letter, I might as well spend a minute on this. When you get let's say you file a case with 10-care eligibility, you turn in your 16 application, takes them 3 months to look at it. They look at it, they ask some questions, you send them the answers. Then they finally issue the approval. Let's say everything went great, and they're going to say, yeah, you're approved for Choices Level 1, which is long-term care, right?
Yes.
Nursing home. When you get it, right in the very front, it says, you have been denied coverage in big bold letters, okay? And then when you find, and that happens a lot, but there's something we call QMB and SLMB. QMB is QMB, it's Qualified Medicare Program, and SLMB, I call it that so long I forget what it's, but anyway, they are Medicare, they are programs where if you are below a certain poverty level of income, very low, like below like $1,300 or $1,400 a month or something, or your whole income is below that, okay, a month, then they will pay some or all, it's a sliding scale, of your Medicare payments. That's the insurance part, right? And that's what that, so the M stands for Medicare program, 2 qualified Medicare programs. And most of my clients don't qualify for that because their income's not that low. But if your income's really low, you get it. But they start out and they say that you have been denied coverage. And if you keep reading the sentence, they say for QMB and SLMB, which happens almost every time for my clients. But you know, if you were to get this, let's say you're a layperson and you tried this and you get this letter in the mail, I mean, it's going to.
You think it's all over?
Well, it shocks you into. Well, I guess I guess we got to throw in the towel on that. But they don't, like page 4 or 5, it goes into says, you have, but it's not in big letters. It just says you've been approved for Medicaid, long-term care services.
Yeah.
And then here's your patient liability that you're gonna have to pay every month, which is typically your income.
Yeah.
And then they lay it out. So I know how they're written now, but I was at some symposium one time, or some continuing learning education where
Yeah.
I attended on this topic, and the person that deals a lot with all 50 states, and put up letters from about 4 or 5 other states, and they all kind of do the same thing, and some of them are really even worse. But I'm just saying, I don't get the concept of that. I think it's kind of scary.
It's because, don't you think these states borrow from each other's policies?
It seems like they do, but I mean, there's, when you do an advertising, you do a commercial, believe it or not,
Yeah.
sometimes I don't believe it, people put thought into that, and they say, okay, what we're doing is a concept that sells, it gets people
Sure.
interested in our product. And,
Sure.
sometimes the commercial's so ridiculous, I say I wouldn't buy it just because the commercial is so stupid.
Right.
But some kind of thought goes into it, right?
Yes.
A psychological thought. And I can only assume, since other states do it, I mean, not all of them could have come up with such a bizarre idea on their own. There's a reason for doing it, but it escapes me why. But anyway, I know how to read them, and so I don't get fired up about it. But this one, they did deny us for for being over-resourced or something. And that's 100% inaccurate, because I know exactly what we did before we sent it in. So we said no, they're not, and we want an appeal, and please send us a date. They didn't, and we were just about getting ready to do that, and they just kind of folded. And they said, well, we looked at it, and okay, you're approved. And no explanation. Here's the thing, I've talked before about, before I did this, I used to do a lot of criminal defense work, right?
Yeah.
And I was a trial attorney. I did a lot of trials. I mean, nobody tries cases these days. I did a lot of them. I think I was getting on the federal public defender panel, or I was thinking about it, and I had to go through everything. And I think I had, something like over 300 and some jury trials, which is a lot in 10 years.
Oh, yeah.
But in court, when you file a motion, you ask for something. That's what a motion is. You're asking for something. And then you explain why you think, what you want, and why you're entitled to get it. Legal authority is to, hey, I'm entitled to a warrant for this search, and here's why. Stuff like that. And they search without a warrant, or something like that.
Yeah.
You get all this explanation. Then you have a hearing, and then the judge or the court makes a decision, and in their order, they'll explain why they think you persuaded them that you should have it,
Yeah.
and why. And they'll explain why you didn't persuade them and you shouldn't have it. But you'll get an explanation.
Right.
Not that way with 10-care. You just get a no. Now, sometimes you'll get a couple extra words like, you were denying your coverage for being over-resourced.
Yeah.
But they don't tell you what resource put you over the limit or anything like that. And there's no explanation. That can be very frustrating too, especially when you're asking for an appeal. All you can do is, well, we're going into this appeal now just with the argument of what we had when we filed the application, because we don't really know what their problem is. And sometimes I can read between the lines. Sometimes you'll file an eligibility application for a spouse,
Sure.
one member of a couple.
Yeah.
And now married rules are way different than single rules. Okay, there's a big difference.
Yeah.
And sometimes they'll deny you and they'll say certain things, and it leads me to believe they're treating this person as if they're not married. Because what they're doing is they're denying him based on something that doesn't apply to a married couple.
Right.
Or not the couple, but a spouse, sure, where you have an institutionalized spouse and a community spouse, okay? And so sometimes I can figure out kind of where they're going because of the way they do it. But it's frustrating when you just don't get it. But so when I talk about people doing do-it-yourself applications, I don't really want to talk you out of it. I will say I don't think it's a good idea, because you'll get blindsided by this stuff and you just won't know what's going on.
Yeah.
And you'll just think, well, we're screwed. And you'll just throw in the towel, which I think is kind of what, I hate to, I can't, this is my opinion. I think maybe that's what the cause and effect.
It certainly sounds like it.
Well, think of it this way. If there's 10 inappropriate denials, and 3 of them are cases like mine, where I go to appeal and I'm now successful.
Right.
I mean, I'm not saying that to pat myself on the back. I'm saying that does not leave 7 other cases that they didn't have to pay out on.
Yeah.
I mean, if the other 7 just say, well, I guess, gee, Margaret, I guess they're not going to pay. I guess we'll have to do it ourselves.
Yeah.
And just drop the ball, just drop it. I think that might happen a lot. And if it does happen a lot, then it's a numbers game, right? And they probably don't mind the fact that 3 of them end up getting approved because 7 of them didn't. So in the long run, it's probably money-saving thing. Now, I can't say for sure that's what they do. It's my opinion.
Yeah.
Because it just fits all those kind of facts. I mean, it's, you know, it is, especially in the appeal process, you know, in the appeal process, it is a court proceeding. It's an administrative court, but it's still, which is a little more, less formal, but all the rules still apply.
Yeah.
You know, discovery and all that stuff, and we never get in. I ask for it every time, never get it. I complain about it every time, never get anything done about it. It's just the way they do. I mean, I'm always successful when I appeal. I've never been not successful. So I pick my battles. You know, do I want to spend a lot of my time
Yeah.
making them provide discovery? And it's really stuff I already know and have anyway.
Yeah.
It's just that the rules really do require it. Now they do, what they do is when you file an appeal, they just send you every piece of paperwork that's ever been filed in the case. Well, I know what that is because I filed it.
Yeah.
Except for the letters they wrote, I got those too. There's no original thought of theirs as to why this is going on.
Interesting.
So, I don't know. One of these days, when I have time, which will never be, I'm going to get up with my state legislature and I'm going to pose a couple questions to the Attorney General, and, you know, about TennCare and say, you know, is it legal? For, you know, is it appropriate or legal for this organization to do this or to not do this or something? And then they have to answer the question. But I don't know. It takes time, energy, and effort.
I was going to say.
A lot of people that need help now. I don't have time. Well, I'll find time someday.
Yeah.
I know I got a case. This next one I'm going to tell you about is a case where had the gal. This one. I mean, if I'm going to get a hold of the TennCare ombudsman on this one again when I find the time. But something has to be said about this one. Got a gal that was in. Now this is a person that's in long-term care, but they're not. Not everybody there is under dementia or Alzheimer's,
Sure.
right? You know,
Sure.
this person's there under physical things. It's like multiple sclerosis or something like that. Where, she's got a motor control problem and
Yeah.
can't get where she needs to be, can't take care of herself when it requires personal mobilization here and there, right?
Right.
But she's got her wits about her, no doubt. I call her on the phone and ask questions. She calls me and asks questions. I mean, she knows her brain is working just fine.
Yes.
With the exception of the synaptic nerves that make your muscles do what they're supposed to do. You
Right.
know, so you can be there for a non-progressive dementia type disease.
Sure.
Although there is a lot of that. But
Sure.
so they contacted me, her and her family, and they decided to hire us. Okay, and so when they hired us, what we found after we were retained to do this job was that the facility filed an application for her. And we came across it, and so I demanded a copy of it, and they gave it to me. And I took it to her, and I said, "Is this your signature on here?" And she goes, "Well, it looks like it, but I sure don't remember signing a TennCare application." She said, "That's why I called you. I listened to you on the radio, and I wanted to get it up." And I said, "Well, I don't get it." She goes, "Because she's not cognitively declined. It's not like she could just not remember she did it."
Yeah.
You know, she was adamant about it. She said, "I don't remember doing it. I'm not even sure that really looks like my signature." But it was done by somebody there, called themselves what they call an assisting person, which you're allowed to have.
Sure.
And now, if that's not bad enough, I mean, taking it on her face value, I guess maybe she signed it, didn't know what she was signing, apparently.
Okay.
But here's the thing. They filed this application, and these facilities, they often have a department, I don't know what they call it, but they got people in the department that assist people with their TennCare application.
Yeah.
It's a big, long 16-page application, and they assist them with that. And they will approach them and say, "Hey, we'll do this for you, we'll file it for you for free," and they will. But here's what they do. This person had some real estate. Okay, they had you're familiar with real estate, so
Yeah.
you can relate. She had two pieces of real estate. One was her primary residence. Now that enjoys a certain status that we have to deal with, and that status is beneficial up front when you apply.
Yeah.
We deal with it later after approval to protect it, but nonetheless, it has a certain. It's a countable asset, but it's an excludable asset.
Yes.
Now, anything else you have, real estate, is considered other real estate.
Yes.
Which is a pure countable asset, no enjoyed status of any kind. It is something you will be expected to cash out and sell to pay for your care before you can ever become eligible.
Yeah.
So she had these two pieces of property. Now, we ended up dealing with the property, had a family member buy it, we structured an annuity out of it, but she had this, and so when I get this application, they go to the person and they say, "Do you own any real estate?" "Yeah." "Do you own a home?" "Yeah, I own a home." "Okay, what's that address?" "And do you have any other property?" "Yeah, I own this other piece of property too." And they write it down. "How much money you got in the bank?" "Well, I got, $20,000 in the bank." And,
Yeah.
"What else do you have?" And they go through all this and write it all down. They say, "We'll file this application for you." So they do, they send it in. And I'm sitting here saying it doesn't take a PhD to figure out that they're going to deny this application for being over-resourced. And so my problem is this. We got a department that says we help you with your application. I mean, is it asking too much for them to know and understand how to fill one out? Because this application they sent in was doomed for failure before it was mailed.
Yeah.
Because she was clearly over-resourced on the application. So who would send in an application knowing it would be a failure? Now, if you know it's going to be a failure, what is that? I mean, that's flirting with fraud, isn't it? Asking for public benefits when you know you're not going to get them or you're not entitled to them.
Yeah.
So I have a problem with that. Now, if they say, well, we didn't know they were going to turn it down, well, then you shouldn't have a department that says we help people with applications, because if you didn't know they were going to turn it down, anybody that has any knowledge of the rules knows it's over-resourced and it's coming back with a denial. So much so, it's going to get denied at the first look. Right out of the gate, the first person that looks at it is going to deny it. I mean, that's an absolute legal assurity.
Yeah.
It will not actually, and if you say, well, we just do it that way because maybe we'll get lucky and it'll go through. Well, if you're doing that, you shouldn't be doing applications because you don't know what you're doing. And so now that can cause some other problems, because once you file an application and you send it in, you now suddenly, or the patient suddenly has a preferred status, and it's called TennCare application pending. What that means is the facility must now treat you as if you have already been approved. Now, you won't be approved for about 3 months, but they have to treat you like you are.
Right.
Which means you only pay the patient liability, you don't pay the whole $10,000. And 3 months later, if you get approved, then they go back to the filing date and they pay the facility all the back stuff.
Okay.
So they get paid, you just don't pay it up front. And so, I forget where I was going with it now. Okay, so when you file this application, you have this status. And there's some language that I could construe that says if you file a second application, that you don't get that status, because there's some language in the statute about the original application.
Yeah.
So, in other words, you can't file it. Let's just say you're completely, you're completely over-resourced, and you completely are not eligible. But you file the application, you get this status. It takes them 2 or 3 months to look at it, right? They come back with a denial. So you know what, we don't have to look at this very much. You're way over-resourced in every category. So you file another one. And you say, I'm going to get the pending status so I don't have to pay, right? You can keep doing that, right? So there's a vehicle of abuse there, which is why it's limited to the original application. Okay, And
Looks
so
like
now I'm dealing with an original application that's failed, and I haven't got a chance to do mine, which I know will work.
Right.
But anyway, what we did was we got in there in time to pull it.
Okay.
And so I'm going with the theory it's not the original application because we pulled it before it reached fruition. So
Yeah. My mic has quit working. Hang on just a second.
it did.
Let me check this for a second.
Does it know something? So did mine.
Check,
just
check.
Mine just quit too. Oh, no, it's back.
I turned it back. I'll have to use the guest mics, I guess, for some reason here for something. But I guess I'm thinking, okay, the facility uses that as a tool to see the assets of the person they're taking care of.
Well, that because it's very intrusive. The application is very intrusive on your.
I mean, honestly, that's kind of a devious thought, I guess, but my thinking is okay, that facility, whoever's doing that, is just using that as a tool to see the assets of the person they're taking care of. And
well, they have their own ways of seeing that too. They do their own asset search, and real property is easy to find if you own it.
Yeah,
stuff like that. So, possible. I mean, I don't know what they can do with it other than. I mean, I get that a lot. I'll file an application. Somebody in the facility will send me an email and say something like, "I don't understand what you're going. What are you going to do about this? This money they have or this property they have. Because I've already done something with it, and they just don't understand what we do. So and that caused us an issue because it was first of all, she didn't know what was filed, and I believe her, and second of all, it was doomed for failure when they filled it out. I mean, they couldn't have filed a worse application. It had all true stuff on it, but it was before you do the changing of categories of property from countable to non-countable. So we pulled it, we did ours and sent it in, and this is the one, and we got a rapid response that it was over-resourced. Yeah. And so we filed an appeal, and within a week, they came back and here's what they kind of said, although they don't really explain it very well. They kind of said, okay, no, we're going to approve this application for choices level 1. And we kind of were looking at the first one, and that's what we denied because it had too many resources. But we see that it's been pulled before we actually looked at it. So
Yeah.
So anyway, it was kind of a mess, miscommunication. So they approved that. But on that case, then they turned around and denied the PAE, which is the medically needy part. PAE is the application evaluation.
Right.
Or pre-admittance, and they denied that. And so we appealed that, and I think in just 2 or 3 days, it just came back and said, okay, we approved the PAE. So I don't know what's going on. There was some explanation. We have the PAE results, and they scored them,
Yeah.
low or something. But they turned around and said, okay, we'll approve the PAE for choices level 1, and they did that without any explanation, but with the information they had when they said no. So I don't know. I mean, they didn't have time to go do another one, and I'm in direct contact with the gal. So they said they didn't come in and do one, or she told me, and so I don't get it. But this is just one of those areas of law. If there's ever an area of law where some people need an advocate, man, it is here, because
I would say so.
You're up against the full weight of the state of Tennessee, and I mean, sometimes it just feels like we're winging it, shooting from the hip, and that's a dangerous place to be. I don't like it because when you go into court, you have rules. And when you have rules, you have an expectation. It's kind of like driving.
Sure.
You're driving down the road, and you come to a four-way stop. You expect all the other 3 people at the
to know the rules
to stop, right? And that's an expectation.
Yeah.
So if you just don't follow the rule and just barrel through there, then that causes a problem, right? Same thing with the rules in court. You have a certain expectation of things. We don't follow them. It derails everything. And now, how do we recover from that? Can we even go forward because this wasn't done or something?
Right.
I mean, but that's what you hire me to do. I mean, I've been doing it for years, and so I make it sound like they've got me against the ropes all the time. They don't.
Yeah.
I mean, I've seen all this. I know what to do. It's still there. It's still somewhat frustrating. It's even there after I point it out, and they don't change. So they're not going to change because I ask them to.
Yeah. Yeah.
So we live with it, and we work around it. We do it, and a lot of times this lackadaisical attitude to the rules, maybe I probably even shouldn't say this, but a lot of times it works in our favor. A lot of times.
Interesting.
If you know how to work it in your favor.
Yeah.
And we can. So,
Yeah.
and then when something happens, like, hey, don't look at me, this is what you did, this is what you asked for.
Yeah.
So that's what I gave you.
I'm going to cut the mic for a second.
Okay.
Put this like it needs to be. Now, I'm trying to get this thing. There we
Sounds
go.
like you're back to me.
Yeah, I'm using the guest mic because the on-air mic for myself is not working for some reason. So
Didn't like what you had to say.
I don't know what the deal is on
You
it.
didn't like what you had to say.
It did it earlier to me, and I had to mess with it and got it working again. But anyway, no problem. Just this week, I was helping a family prepare to liquidate an estate. And I think of you every time I'm dealing with this, and I deal with it a lot. I deal with it a lot, and thanks to you and others and some experience, I kind of know what they're handling, know what they're doing. In this particular case, Stan, I really thought of you because the deceased person had no heirs, no spouse, no children, and had made no preparations for anything. Okay, so a cousin from out of town had to come and handle things. And this is, and I kept thinking, and of course I had this discussion with these people just this week, and they were talking about how they have learned,
Right.
a little bit about how this works. And so after everything's done and everything's liquidated and they go through the state and, get all the bells and whistles, I mean, there was a lot of work that this person had to do. And what would have been an inheritance for someone if she had, if this person had decided to make some plans.
Right.
For this, her inheritances or her estate could have gone to someone or somebody or something.
Right.
As it's going to wind up, it's going to be distributed between 20 cousins.
Yep. That's called the laws of intestate succession.
Exactly. You've talked about that.
Yeah.
So, and I just ran into this week. So I'm saying, look, if you haven't done any kind of preparation at all, then someone else is going to decide, and it's going to be the state. And they're under the rules to just find the closest, and that's the way it works.
It's already been decided.
It's
They're
already
going to
been
look at your heirs. Let's say you have kids. Or
Yeah.
somebody has kids somewhere
Yeah.
along the line.
Yeah.
And they have kids. And they have kids.
Yeah.
And you pass away, and it goes down that chain, starts looking. It's probably going to find a lot of people.
Yeah.
And then everybody gets a 1/4 50th of the cut, you know what I mean? It's just.
Yeah, and the poor person who was having to handle it was so frustrated
Oh
and
my
trying
gosh.
to get through this, deal. And so anyway, but it had to be done.
I can't tell you how many times people come to me and they'll say, you know what, my mom or dad or my uncle or on my wife's side, this
Right.
thing, I had to be in probate, had to be in this, and it's just nobody ever come in and said, hey, we went through probate, and it was okay, it was kind of fun.
Yeah.
I mean, or it was a blast. We had a
Right.
good time doing it. No, I never get it. The best I've ever seen is sometimes people said, we did probate, but I don't remember it being too big of a deal.
Right.
And usually if I inquire about that, because there's really no point inquiring about it afterward, but if I inquire about it, usually it's that way because the person didn't have anything.
Yeah.
There was nothing to
There was
nothing to make
nothing
it
to
be
divide. Yeah.
nothing to make it to be a problem.
Yeah.
And but I get that feedback from people, and I came to that conclusion years ago, and I stopped doing probate. I don't do it. So if people call me all the time still, and say, "Hey, somebody passed away. Can you do the probate?" And I say, "I don't do probate." And they say, "Well, you talk about it all the time. I hear it on the radio." I say, "No, I talk about probate avoidance all the time.
Yeah.
That's what I talk about. I don't do it anymore. I don't do it because of that.
Yeah.
It ties up my resources, my office, for a year
Yeah.
on each case." And here's another thing with probate. Now, this is just a generality, so don't get mad when I say this, but I always used to have the conversation with people and say, look, this is going to take a while. I mean,
Yeah.
we can't even close the estate till 12 months after death because of the creditor's rights, okay?
Right.
So we're looking at a year.
Yeah.
And everybody said, okay, that's fine. We'll just, whatever it takes, we'll do it. So we start. Well, 6 months later, I get these angry calls. What's going on? Why are you dragging your feet? Why can't we have our money? Why can't we distribute? And so, you remember that conversation we had 6 months ago? And
Yeah.
of course they don't.
Yeah.
and they're yelling at me, and it's like, I just, it consumes too many resources. I don't like doing it.
Yeah.
It's like when I practiced other law. I never did divorce work. I think I did a couple of uncontested ones, but I just didn't like it. I
Yeah.
don't like that kind of law, so I don't
Yeah.
do it. But I don't do this because it's just too much for my office to handle because we do so much of the probate avoidance work, the trust work, and
Right.
stuff like that. So, but I refer it out. I have an attorney that I refer to that takes those and does a very good job and treats her clients very well. And she likes doing it, and that's who should be doing it. Somebody
Yeah.
that
Somebody that wants to do that. Yeah.
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 Just like I like doing what I do. That's
Yeah.
it.
And me too.
Yeah,
We
yeah.
finally found our lane, I guess.
That's right. My old man used to always say, if you got to get up every morning at 6 o'clock to go to work, you darn sure better like what you're doing.
Yeah.
And that always stuck with me.
All right. Well, we got, looks like one of our regulars is calling in,
All right.
and we'll see what's up with Peggy this morning. Hey, how are you? Yes, we can. I'm not sure how that. Yeah. No.
Well, not entirely clear, but let me take a stab at it.
Okay.
I think we're kind of distill that down into this other house,
Yeah.
okay, and how it goes to the children, whether it's in the trust or not in the trust.
Yeah.
Because they talked about somebody being in care.
Yes.
But the question didn't seem to have anything to do with that to me.
Yeah.
And they talked about where it goes, and the person wasn't dead yet, so it's not going anywhere, but where it will go. So here's what I think it is. If I'm off base, maybe call back. But you have this, you know, if you have a house, or let me back up a little more. If you have a trust, you got to put property into the trust.
Right.
Because there's language in the trust that says, here's where the property in the trust goes. So the trust only has control over property that's been funded to it.
Right.
So if you put a house in it, and you say, this house goes to my 3 children, a
Yeah.
third each, or it all goes to my oldest son, or something.
Yeah.
That's, the trust will control that, you know, probate free under the trust code. That will be distributed in accordance with the terms and conditions of the trust. Now, if a house is not in the trust, you never got around to funding it to the trust, then it's not in the trust. And the trust can't control its distribution.
Right.
But the trust plan will, and here's how the trust plan controls it. In the trust that I do, we always do what's called a pour over will. Pour over, P-O-U-R-over will. It's a special kind of will. It is a last will and testament, but it's a very special kind of last will and testament that pretty much says, hey, I got this trust. In other words, this will doesn't say I leave this to my kids, I leave this to my wife, I leave this to my buddy down the street.
Right. This
trust says, hey, this will says that we have a trust. We funded our trust. It was our intent to fund our trust with everything we own.
Yeah.
However, if there's anything we've forgotten, neglected, or otherwise overlooked, this wills it to the trust. So the only beneficiary of this will is the trust. So if you have this house that's not in the trust, this will sends it to the trust, and then the trust controls the distribution of the property. Works very well. Now, so even though it's not in the trust, it's going to end up in the trust. Now, the will, the pour over will, is a probate activity. It's an instrument. Now, so our goal is to fund the trust and have the pour over will be a waste of paper and a waste of ink and never used. That's the plan A.
Yeah.
Plan B is if we do drop the ball on something or just don't know about something, it never gets put into the trust. This will send it there, but it is plan B because it is a probate instrument, and it's usually an abbreviated version of probate when we do that.
Yeah.
But it's still
Interesting.
probate. It is still probate. So
I think we've talked about this in the past somewhere along the way.
how it will, you know, so I'm not sure I really am answering the question, but I think I'm on the same track, but I don't know that I got.
I wonder, she may be thinking too, is the trust, the house that may or may not be in the trust, if it's not, will the healthcare facility have some claim to that?
Okay, let's put the healthcare, let's talk about the connection with long-term care.
Yeah,
right?
yeah.
Well, it depends on the kind of trust.
Yeah, it does.
Some trusts protect assets from long-term care and some do not. You know, you talk about me, the 2 main trusts I do, we do some other trusts like special needs trust and stuff like that. But the 2 main trusts we do is the revocable living trust, which does not protect assets from long-term care or any creditor. And we do the asset protection trust that does. So if it's in a revocable living trust, it doesn't matter if it's in it or not in it, it's available for the cost of care. If it's in the irrevocable trust, the asset protection trust, it is not available for the cost of care, so it's not in the equation when they try to determine what you own. The one that's out of it is exposed to long-term care.
Right.
Now, I've not got to death yet where we distribute property at death.
Right.
I'm talking about during life.
Right.
Which is where the asset protection trust really does all of its work.
Sure.
You have a revocable living trust, and when I talk about those, I say, hey, you're the trustor, you're the maker of the trust, or you and your wife, and you're the trustee, you or your wife, you know, during your lifetimes, you're the maker of the trust, during your lifetimes, you're the trustee, and during your lifetimes, you're the beneficiary. So, because and that's all 3 parties of the agreement.
Right.
So, because you're all 3 parties of the agreement, you have 100% access to the property anytime you want, for any reason or no reason at all. I mean, it's unfettered access, right? Because you have that much access to the property, now, you know, there's something I tell people at the seminar to memorize, and that is if you have access to an asset, so do your creditors.
Yeah.
If you can get at it, they can get at it. So in a revocable living trust, you can get at it. There's no control restrictions. It's all, you can get at the principal and do whatever you want with it. Put it in trust, take it out of the trust, spend it, not spend it, anything you want to do. Like I say, for any reason or no reason at all. Now, because you have all that access to the property, you don't get creditor protection, because that violates the concept that if you own something, a valid creditor is entitled to satisfy a judgment by going after that.
Yeah.
And so, but if you put it into, so if you have a revocable living trust and your house and stuff is in there, that's available accountable asset for long-term care.
Okay.
Now, the primary residence has a somewhat special status, but it is still in there. You know what I mean?
Right.
It's not protected. The other real estate too. Okay. So in the scenario she gave, if it's in the trust, is it protected from long-term health care? It depends on which trust. If it's not in the trust, then it's absolutely exposed. no
Right.
matter what.
Right.
So, that's exactly what the asset protection trust that we talk about solves a very specific problem. The problem it solves is it protects you, the maker of the trust, from your creditors during your lifetime. Okay?
Yes.
Because if you have, let me back up a little more. Suppose you have a revocable living trust or a will, and it says in both of those, it says, everything goes to my 3 kids. Okay?
Yeah.
Does that not presuppose you have everything at death?
Yes.
I mean, if you have nothing at death, you give them a third of squat, right?
Yeah.
Now, so the question is, what can happen during my lifetime that's going to exhaust my estate? Because when I wrote the trust or the will, I apparently had everything, and I wanted to go to my kids. So what can happen during life that can exhaust that estate? And enter long-term care, which is going to happen while you're alive. So that's the problem the asset protection solves. At death, the asset protection trust works like any other trust, because it's already done its work. It protected everything during life. At death, the creditors are essentially out of the picture, and it just distributes the property. But the advantage is the property is still there to distribute, because it has been, the stuff that was in the trust was shielded from those creditors, and we know for a fact when we put it in that trust that when we die, it's going to be available to go to where it's supposed to go.
Perfect.
So that's why I say it depends on the trust. The revocable living trust is a grand tool. I mean, people say, well, if that doesn't protect you from long-term care, what good is it? Well, it's a grand tool, and we do a lot of them, mostly for people in midlife, 40s, 30s, 40s, 50s, that say, hey, I'm still working, we're probably going to change houses 2 or 3 more times like people do. I'm not worried about long-term care. Like I said when I was in my 40s and 50s, I'll worry about that later.
Yeah.
I'm not worried about long-term care. I mean, that's exactly
Yeah.
what. And I get it. That's just the way it is.
Yeah.
And so, but when you get older and get closer into retirement or close to retirement, you start thinking about that stuff, and then it changes. So the revocable living trust does not protect you, the maker of the trust, from your creditors during your lifetime. Now, it protects your kids from their creditors all day long. Any trust can do that, but not you.
Yeah.
And so when you start thinking about this and you say, I'm really worried about $10,000 a month care, I don't know how I'm going to pay it if I get there, and if I do have to pay it, there'll be nothing left to give my kids.
Yeah.
I really want to pass my inheritance on. Like you said 2 weeks ago in Scripture, I want to pass it on to my heirs like God wants us to do.
Right.
And but if this happens, it's going to get exhausted, and they won't. Well, when you get to that point, then come talk to me, and we can put it in this trust. I don't get a lot of people that put it in the asset protection trust early in life, and I get it. It's just a philosophy thing.
Yeah.
And because when we put it in there, remember I said if you have access to it, your creditors have access to it.
Yeah.
Well, if we put it, what we have to do is create a situation where you don't have access.
Right.
Now, it's not as bad as it sounds because we still can get at it. Access is a legal word, a legal concept.
Yeah.
It's a certain way you get to the property.
Yes.
And we're not going to have that and the reason we're not going to have it, because if you have it, they have it.
Yeah.
So if we don't want them to get it, we can't have it either. But it really is, we still can get at the property. It's just not access.
Right.
So when you say access, it doesn't mean just going to get property. Basically what it means without a whiteboard. Principal cannot come out of the asset protection trust and go directly to one of the makers of the trust.
Yes.
You can come out of the trust and end up with you, just can't do it that way. So there are some limitations and restrictions on our access to the property. We maintain 100% control. If you want to sell the house, sell it. You want to buy a new one, buy it. It just has to stay in the trust to stay creditor protected, right?
Excellent.
So if you sell a house, and you got a house, you put it in the trust, and it's protected. And so 5 years from now, you wake up and you say, screw it, we're moving to Florida. I've had it, I'm just going, okay.
Yeah.
We're moving to Florida. The question is, can I sell a house that's in an irrevocable trust where I have no access to the principal? And the answer is absolutely. Sell it. Call your real estate person, say, I want to sell my house. Let's use easy numbers, $100,000 house. And say, I want to sell the house. Okay, you get a buyer. So what do you get when you sell a $100,000 house? It's not a trick question.
Oh.
What do you get?
You get your money.
You get the money,
Yeah.
right? Now, the money has to stay in the trust to stay protected.
Right.
So if you get to the closing, when you get to the closing of this sale, you say, oh, hey, wait a minute, don't make the check out to me, Stan Pierchoski. That $100,000 check for the sale. Make it out Stan Pierchoski, trustee of the Pierchoski Trust, okay?
Right.
And then when I get the money, it's not left the trust.
Yeah.
So what has happened? The asset never left the trust. That asset just changed posture from real estate to cash, right?
Yeah.
It's still an asset, still protected. I go to Florida, I buy a new house, I get to that closing, I say, whoa, don't make the deed out to me, Stan Pierchoski, the individual. make it out to me, Stan Pierchoski, the trustee of my trust, or whoever the trustee of the trust is.
Right.
And it's the new houses in the trust. All this control happened and never left the trust.
That's right.
And you just suppose you got money in the bank and say, you know, it's not doing squat. I think I want to put it in cannabis stocks. I think they're going to take off.
Yeah.
You could do that. The cannabis stocks have to be titled to the trust to stay protected. I want to put it in a CD. Bank over here's got great rates. I'm going to dump it all into a CD. Put it into a CD. You can do that every day of the week. You just, when you get the bank and you sign the contract, put down as the owner, the trustee of the trust. So it's never left the trust. You can manipulate it. You can put it, you can change it to gold. You can change it to a CD, Edward Jones, Raymond James managed account, stuff like that. You can do all these things. It just has to stay titled to the trust. So if you black box this trust, that money's in there. And if it's in the trust, it's always protected. It doesn't matter if it changes posture from real estate to cash, back to real estate, to CDs, to gold, to an Edward Jones account. If it's in the trust, it's protected. But so you have all this control over it, but you can't. The principal cannot come out of the trust and go to you.
Yes.
It does. We've exposed it. I'm not saying there's not like the police will come to your door and arrest you because principal came out and went to you. What's going to happen is if I get to that first closing, I say, hey, make the check out, the $100,000 check out to me, the individual. Well, I've just taken $100,000 out of a protected format and unprotected. Now I have access to it because it's a check in my name.
Right.
Now if I want to put it back in the trust, I trigger the 5 years again.
Yeah.
And I've already been there 5 years. So there's a right way to do it. And you have to, it's not really rocket science, but you got to do it that way to keep it protected. Now, fortunately, in this neck of the woods, these trusts, it's very, very common that the only thing in this trust is the real estate. In which case, there's really not much to do, during lifetime. But it's all protected. You got these big ticket items, hundreds of thousands of dollars worth of real estate. Any piece of real estate's worth a couple $100,000, right?
Yes, yeah.
A $100,000 house, in my example, would probably be some Tobacco Road tar paper shack somewhere these days, right? So you put your real estate in there, you're protecting hundreds of thousands of dollars of property.
Yeah.
And so, I mean, I kind of went through that fast. We talked about that before.
Yeah.
But that's, the Asset Protection Trust solves a specific problem, and it's that problem during life.
Yeah, absolutely.
So anyway, and it works very well. It works very well. I've seen enough of them mature. I've sent enough of them to TenCare. They know how they work. They like to scrutinize them because there's a lot of them out there that are written that are not written well.
Yeah, yeah.
They'll have little clauses in there to say, well, I don't have access to principal, but if my wife or I get a really bad disease and we have to get the assets for it's life or death, then we can get at it. Well, they're going to look at that and they're going to say, I see that's access. Yeah. And they're going to hammer you for it. I mean, that's just the way it works.
It just makes good planning sense for you and your family. And that's what your office is all about, Stan.
Yeah, I mean, I kind of got fired up there. I like doing this asset protection trust. It is a grand tool, and we are fortunate to have it available to us.
Yeah.
So, you're right. I'm biased, of course. You should plan at any age, because, that's the old thing, stuff happens, right?
Right, stuff happens.
And it does.
Yeah.
And sometimes I tell people, they say, I've been wanting to do this, I'm worried something's going to happen, and we signed everything, and they say, I'm so glad this is done now. I said, well, now, under Murphy's Law, you're pretty much guaranteed that nothing bad's going to happen, right? It's going to happen bad when you're not planned and ready for it, right? But everybody has heard horror stories, like the one you're talking about, and you don't want to be in that, and you don't want to put your family through it, because it may not be a horror story to you, but it certainly could be one to your heirs after you're gone, and nobody wants to do that, because you care about your people. A lot of times some of the stuff you do is not for you. I mean, the long-term care is for you, but a lot of this you do for your loved ones. Yeah. That's all there is to it. So, absolutely. And it's people really want to know how this works. That's why so many people come to the seminar, because they go searching for the information and it's not there, or what's there is so confusing or so contradictory, or so inconsistent that they don't know what to believe.
Yeah.
So hopefully they believe me. I like to think I'm a source of knowledge. I'm usually bound to my opinion when I do that sort of stuff, so a little more thought goes into it. But anyway, I see we're coming up on the end, so real quickly, next seminar coming up is January the 24th. That's roughly 2 weeks from tomorrow. What's the, that sounds about right.
That's right.
2 weeks from tomorrow, it's going to be at the Star Theater. That's right on the square in Pulaski. The physical address of that is 105 North 1st Street in Pulaski. It's at 10 o'clock in the morning that day. And we call it Wills Trust and Nursing Home. If you want to come to it, give us a call. Let us know you're coming. Tell us how many. Bring as many people as you want, or come by yourself. It's no big deal. Now, I used to say it's right next to my office on the square. My office has moved.
Yeah.
Bad news is we moved. The good news is we only moved 2 blocks away.
Yeah, that's good.
You can see one from the other. So that my sign might still be up. I'm still working on the signage on a new place, but we're fully operational there now.
Yeah.
And but like I said, it's a house off the square. It used to be a State Farm Insurance
Yeah.
business, and
Yeah.
you know it was perfect setup. So we kind of moved into it.
Good for you, man.
Yeah, it's
I was thinking about this too. The Star Theater, is it, the spelling of that is funny.
2 A's.
It's STAAR.
Right. It stands for Southern Tennessee Area Arts Repertory
Okay.
Incorporated.
Yeah. There you go.
But it's the big building you can't miss. If you find the square in Pulaski, you'll find this theater.
Estate plan stand, everybody. And
Oh yeah,
by the
you
way,
can go to my website.
That's
Estate
right.
Plan Stand will take you to the website, and you can call from there, or email, or RSVP from there.
that is right. That is right. In Pulaski, Tennessee, and of course here on Fridays, and we got about a minute we need to fill in. So
Let me give you the phone number.
Give me the phone number.
931-363-7222. 931-363-7222. Or if you don't write it down, you just remember Estate Plan Stand and get the number that way. Or you can go to the Estate Plan Stand. You can ask your question by email.
yeah,
A lot of people do that.
yeah. I know you. You can take phone appointments, and of course, my advice would be set up an appointment and get a good counsel.
Yeah, I'll be glad to talk to you.
Good deal.
Well,
Stan,
it's
good to
be
have
back.
you here,
Yeah,
man.
it's good to be back.
Good to be back. We get these Fridays rolling again, and look forward to a good year with you. This would be the year. If you haven't done it, get your estate planning done.
I'm gonna go out and sail back to Pulaski.
Get out. Yeah, we got to get out in this rain. Be careful out there, folks.
Okay. Always a pleasure, Jeff.
All right. See you next time.
Services of Prospect.